Have you ever walked into a store, seen a price tag, and thought, this is the final price? They have to sell it to me at this amount? Well, not exactly. Many people think price tags are binding, but the law says otherwise. Today, we'll break down the difference between an offer and an invitation to treat, a concept that affects shoppers, businesses, and even online retailers. We'll explore why businesses don't always have to honor the displayed price and how this applies in real life. Imagine you're shopping and you see a huge sale sign. Does that mean the store is legally required to sell to you at that price? What about online shopping? When you click Add to Cart, does that mean you've made a legally binding purchase? These are common misunderstandings, and today we will clarify them. Many businesses face legal disputes due to misunderstandings about pricing and contracts. A famous example occurred in 2013 when an airline mistakenly advertised flights for as low as $5. But the airline later refused to honor them, stating it was a pricing error. Thousands of customers purchased tickets at this price. Did the customers have a valid legal claim? We will examine these issues in detail. Another interesting case happened in the UK when a large retailer accidentally listed an expensive television for only $20 on its website. Customers rushed to place orders, but the company canceled them, arguing that it was an obvious pricing error. Should they have been forced to honor the price? We'll discuss how the law treats such mistakes. One of the biggest misunderstandings comes from limited time offers. If a store advertises a one-day sale, but you see the ad the next day, can you still demand the discount? No, because the advertisement was merely an invitation to treat, not an offer. The timing of advertisements also plays a crucial role in how they are legally interpreted. Some people also believe that verbal offers hold as much weight as written ones. However, in contract law, while some verbal agreements are enforceable, many require written confirmation to be legally binding. This is especially true for real estate transactions, which almost always require a formal contract. Let's start with contract formation. A legally binding agreement happens when an offer is accepted. A true offer is when one party clearly states the terms of an agreement and the other party accepts it outright. However, when you see a price tag in a store or an advertisement in a newspaper, that's not an offer. It's merely an invitation to treat. This means the store is inviting customers to make an offer, but they are not obligated to sell at that price. Here's a simple way to remember it. Price tags not equals offers. Customers make the offer at checkout. Another example. A store has a buy one, get one free deal in the newspaper. You rush to the store, but they say the deal is no longer available. Can you force them to honor it? No, because advertisements are invitations to treat. A similar misunderstanding happens in housing markets. If a property is listed for $500,000, can a buyer immediately demand to buy it for that price? No, because the listing is an invitation to treat, and the seller can accept or reject offers as they wish. Another common situation occurs in job offers. When a company advertises a position with a specific salary, is it legally bound to offer that salary to all applicants? No, because job postings are not offers, but invitations to negotiate employment terms. A key case that explains this principle is Pharmaceutical Society of Great Britain versus Boots Cash Chemists, 1953. The case involved a self-service pharmacy selling medicines. The question was whether items on the shelf constituted a binding offer or just an invitation to treat. Another famous case is Partridge v. Crittenden, 1968, where a person advertised birds for sale in a newspaper. The court ruled that the advertisement was an invitation to treat, not an offer, meaning the seller was not obligated to sell the birds at the advertised price. This also applies to online shopping. When you add an item to your cart, that's not an offer. It's an invitation to treat. The real contract happens when payment is processed and confirmed by the seller. Similarly, in auction sales, the bids are offers, and the auctioneer decides whether to accept them. Firm, there's no contract. If a bid is placed but the auctioneer doesn't confirm, another common scenario is advertised discounts. Imagine a store announces a 50% off all electronics sale but runs out of stock quickly. Can a customer demand the same discount on another day? No, because the advertisement was an invitation to treat, not a binding offer. Another example involves restaurant menus. If a menu lists lobster for $10 instead of $100 due to a misprint, is the restaurant required to sell it at that price? No, because the menu is an invitation to treat. Now that we understand the difference between an offer and an invitation to treat, let's discuss what consumers can do to protect themselves when dealing with unclear or misleading pricing. Many countries have consumer protection laws that prevent businesses from using deceptive pricing tactics. For example, in some jurisdictions, if a company deliberately misleads customers about a price, they may be legally required to honor it. However, if the price mistake is clearly an error, such as a car listed for $10 instead of $10,000, then businesses are generally not obligated to sell at the incorrect price. Here are 3 key steps consumers can take to ensure they make informed purchases. 1. Check the terms and conditions. Many online retailers include disclaimers stating that prices are subject to change before checkout. 2. Ask for clarification. If you see an advertised price that seems too good to be true, ask a store representative whether it's an actual offer or just an invitation to treat. 3. Report misleading ads. If a retailer consistently uses deceptive pricing, report them to local consumer protection agencies. Many governments enforce strict laws against false advertising. By being aware of their rights and responsibilities, consumers can avoid disputes and ensure they get fair treatment when making purchases. So, let's recap. Offers and invitations to treat are not the same. A price tag is not a contract, but accepting an offer and making payment is. Understanding this difference helps protect both buyers and businesses in real-world transactions. If you found this helpful, make sure to like, share, and subscribe for more business law insights.